The law of self-defense content you are about to enjoy is presented for general educational purposes only. It does not constitute legal advice. If you are in need of legal advice, consult competent legal counsel in the relevant jurisdiction. Hey folks, welcome to the Law of Self-Defense, our news and Q&A show for August 13th, 2020. This is the one show of the week that we do that's completely open access. Most of our content that we produce, you need to be a Law of Self-Defense member. We'll talk more about that later. But normally you need to be a member to access our content. The one exception is our weekly Thursday news and Q&A show, which goes live every Thursday at 4 p.m. Eastern Time, 2 p.m. Mountain Time, where I happen to be located. For those who may not know, let's see if I can pull myself up here. I am attorney Andrew Branker for Law of Self-Defense. Thank you very much. That's greatly appreciated, as always. Because I know so many of you are not existing Law of Self-Defense members, may be unfamiliar with the Law of Self-Defense community. Law of Self-Defense is a law practice that focuses exclusively on use of force law. That is all we do, all the time. Let me make a couple little adjustments here. There we go. So by use of force, we mean defense of yourself, defense of others, and defense of your property. We cover all of those, and we cover those for all 50 states. So what do I have for you today? Well, in our news and Q&A show, our normal format is I cover some use of force events that have been in the news. Today, those will consist mostly of videos, a couple of very short videos, and then the one I know you're all interested in, which is the brief video that's come out this week of two gunmen, masked gunmen, quote-unquote, protesters, mostly peaceful protesters, I guess they'd be called in the media, two gunmen who stop a blue pickup truck. I've gotten a lot of inquiries about how the law of self-defense applies to that kind of scenario, what that pickup driver would be privileged to do in defense of himself, whoever else may be in the truck with him. So we're going to cover that video in great detail. That'll be the bulk of today's news and Q&A show. We're going to do a thorough kind of after-action analysis, legal debrief of that event, stepping through all 5 elements of a claim of self-defense. Now, the first 2 videos we'll cover are very short. There's really not much to say about them, but I've had a lot of questions, so we'll just go over them very quickly. One is the shooting by police of a man who, well, he points a shotgun at the police. They return the favor, and that ends poorly for the man who points a shotgun at the police. The second video, also very short, is that of a man who attacks a police officer with a knife in each hand. The man has a knife in each hand, and fortunately, that ends with the good guy winning as well. And then that longer video that will do the very detailed brief on the two gunmen who stop the pickup truck. After we cover those news events, we also have a number of questions that have come in over the course of the week. One of those is notes these violent mobs in Portland are now beginning to expand beyond the city center into neighboring communities. What to do about that? What can those people in those neighboring communities do now that they too are being aggressed by these rioters, looters, and hopefully not, but potentially arsonists? We've got a question from one of our Platinum Protection Program members, which always get priority on this show, about the use of unusual non-deadly weapons like paint gun, fired pepper balls, smoke grenades, things like that against protesters. We have a question again from a Platinum Protection member. What about weapon-mounted lasers, non-deadly force lasers that many of us might carry on our personal defensive weapons? We've all heard in the news that the protesters, the bad guys, are using some powerful, actual damaging, blinding lasers on law enforcement, causing permanent eye injury. I've talked about that on previous shows. But what about the purportedly non-deadly lasers we might carry on our personal defensive weapons lawfully? To what extent can we use those as non-deadly defensive weapons, independent of the gun they're mounted to? We have another question from a Platinum member about the fact that I talk extensively in my courses about interacting with the police in the aftermath of a use of force event. But what about if your spouse is with you? What are they supposed to say to the police? What should they say to the police? If nothing else, they're going to be a witness to events if they're present, and the police will certainly want to speak with them. And finally, we have a question about defense lawyers and their privilege to object to the prosecution's arguments during closing statements. So we're going to cover all that today as time permits. Now, before I dive into the show proper, I do have to, of course, mention our sponsor, which is CCW Safe. They're a provider of legal service memberships, what many people mistakenly call self-defense insurance, and they, in effect, promise to pay their members' legal expenses if their members involved in a use of force event. And those expenses start big and get bigger fast, folks. For example, the most common case I consult on are aggravated assault cases where the client felt threatened. They displayed a gun. They didn't fire a shot, didn't hurt anybody, but they're charged now with aggravated assault, which in many states is good for 10 or 20 years in prison, folks. And they're looking at a retainer to their lead counsel in the order of $30,000 to $50,000 for the pretrial work, not for trial, for pretrial work. And if they've actually shot and killed somebody in self-defense and they're charged now with manslaughter or murder, it's very easy to hit $200,000 pre-trial, folks. Just multiply that amount for the trial. So if you don't have that kind of money stuffed in a mattress, just in case you have to defend yourself, it can be useful to have a financial partner standing behind you to make sure that you have the resources you need to fight the legal battle the way you'd want it fought, which is as if your life depended on it. Because, folks, life as you know it depends on it. And that's what CCW Safe offers to do for its members. Now, there are several companies out there that offer similar services. I've looked at all of them, as you might imagine, and I found that CCW Safe is the best fit for me. I'm personally a member of CCW Safe. My wife, Emily, is personally a member of CCW Safe. Now, whether they're the best fit for you is something only you can decide, but I do encourage you to take a look at what they have to offer by pointing your browser to lawofselfdefense.com/CCW Safe, all one word. And if you do decide to become a member of CCW Safe, you can save 10% off your membership at that URL, lawofselfdefense.com/CCW Safe, using the discount code LOSD10. Okay, now let's get back to the show proper, the News and Q&A show for August 13th, 2020, and start stepping through these videos that we have here. Now, the first video, very short, involves a man who points a shotgun at police. Generally, the videos I show don't have any gore in them, folks, and this one doesn't have any gore in it either. But it does show a man falling to the ground after being shot. So if you're uncomfortable with that, you may want to turn your head away for the roughly 1 minute, 23 seconds that this video plays. But with that out of the way, let me clear the screen here for that video. I'm going to go ahead and play that for you now. I believe it does have audio, but I don't believe there's any bad language involved. Now, what I want you to pay attention to here is first of all, how clearly this is basically an attempt to commit suicide by cop. I, in fact, don't know whether the suspect here survives the shot or not. He is decisively hit, as you'll see by the manner to which he falls to the ground. It looks, frankly, like a spinal hit to me, a paralyzing hit. But I want you to note the professionalism of the police officers. They really do everything right here, and we'll step through that after the video. And it also raises some interesting questions about this whole defund the police movement. Because if we don't have these guys willing to go toe-to-toe with someone walking down the street with a shotgun pointing it at people, including police officers, who are you going to call? But in any case, here's that video, and then we'll come right back.
How you doing, Ruffin? How are you?
That is, in fact, the wrong video. So let me step back and try again, and this time I should have the right video. Sorry about that. Here we go.
Hey, bro. Drop the gun. Drop the gun. Drop the gun. Shot fire, shot fire, shot fire. 1040. Don't move, man. Don't move. Stay still. Shots fired, Seth. We got one male down.
10-4, shots fired. One male down, 1046.
Hey, man, you good? Stay still.
Okay, so there we go. Let's step through it quickly here. First of all, note the cops, they really do everything right here. They give the man an opportunity to drop the gun, even after he raises the muzzle at them the first time. Then they fire a single shot when he raises the muzzle a second time. That takes the suspect down. They approach reasonably with an expectation the man could still be a threat. But once it's apparent he's no longer a threat and the scene is secured, then they can begin providing care. They begin asking him if he's okay. Well, he's not good, obviously. He just got shot. But they're talking to him. It's not like they're beating him, for example, when he's on the ground. This is the way it's supposed to be done. In terms of any prospect for a non-lethal intervention by the police, folks, non-lethal against a shotgun doesn't work. Shotgun may not have much reach compared to a rifle, for example, or arguably even a handgun in skilled hands, but it has vastly more reach and more potent reach than a taser, for example, or a beanbag projectile or pepper spray or any other non-lethal means. There'd be no way for officers to deploy those kinds of non-lethal tools without exposing themselves to imminent deadly harm. So as far as I can tell, cops did everything perfectly appropriately here. A negative outcome for the suspect, positive outcome for, well, everybody else in the world. And of course, it raises an interesting question about this whole defund the police movement, folks, because who's going to respond to a dude walking down the street pointing a shotgun at people, including at the police, if not the police? Are we planning to send a social worker to talk that guy down? Because I don't think that's going to end well. And this next video just reinforces that as well. So let's talk now about the cop who was attacked, the second video. The cop who was attacked by a suspect who he appeared to know. The way the cop communicates with the suspect, he calls him out by name or nickname. I expect this is a emotionally disturbed person who's known as such in the community, including law enforcement. I'm sure the cops got plenty of calls about this guy many times, and now they're responding to yet another call where the community is disturbed about this person's behavior. I don't know that for a fact, but that's my sense from the video and the demeanor of the people involved. So what we'll see here is the cops initially in his car. He pulls up. We'll see him holding his notebook. This is all body cam footage now. He gets out of his car. He begins conversing with the suspect. And what I want you to note here are a few things. First of all, note how fast things go south. This whole video's only about a minute long. And it's a fraction of that time that goes from the initial inquiry of the cop to the suspect, asking him if he's doing okay, to the point when the cop has to shoot this suspect to the ground with multiple shots fired. Happens very, very fast. And by the way, this could have happened quickly to anybody. It didn't have to be the cop, right? It could have been any pedestrian. It could have been us walking down the sidewalk, walking our dog, walking with our kids, walking with our spouse, who suddenly got targeted by this now lethal, emotionally disturbed person with two knives. The other thing I want you to note is how much stress the officer is under by the end of this. This is a very short encounter. Probably the whole physical encounter is maybe 30 seconds. And yet at the end, you will hear that officer breathing as if he's just run a mile. Now, that's not the physical stress that induced the physical exercise that induced that degree of stress. It's the fight or flight adrenaline dump, the stress chemicals, hormones that are dumped into the body that trigger that kind of response. And that will happen to all of us, folks. You have to expect it's going to happen to you too. And how are you going to conduct yourself? How does it impact your ability to respond to events, to perceive, capture, store, recall information about the event, especially in the context of providing a narrative after the fact about what actually happened in an absolute sense? So again, very short, not gory at all, but again, someone is shot in the video ultimately, and there is a violent attack upon a police officer. So if you're sensitive about that, this video runs about a minute. You might want to divert your gaze from that as well. Okay, folks, here we go.
How you doing, Ruffin? Are you fine? Are you fine this morning? Can you just have a seat for me? Can you just have a seat for me? Step back. You're going to get tased, bro. Step back. You're going to get tased. Step back. Step back. You will get shot. Shots fired. Shots fired. 458 headquarters. Shots fired. 458 headquarters. Shots fired. 458 headquarters. Shots fired. Send all units.
98. Affirmative.
And there we go. So everything happens very quickly, very, very quickly. By the way, you think it might be useful to be able to engage in a target while you're attempting to maintain distance from that target, moving backwards? Because if that cop had simply stood his ground and fired shots like we might in a local pistol match against cardboard targets, and the guy with the two knives had gotten on top of him, you think 3 or 4, 5 9mm rounds in the guy with the knives is going to keep him from cutting that cop up good, likely fatally? So the ability to maintain space, really, really important, folks, especially against that kind of impact-bearing attacker. So this cop, again, it appears to me he did everything right. He certainly wasn't overly aggressive on first encounter with the suspect, was giving him verbal commands. And by the way, folks, one of the reasons you give verbal commands, one of the reasons is you hope they'll obey the verbal commands, which would be great, right? If the guy with the knife keeps his distance, stays back, sits down like you tell him to, that's awesome. The other reason you give verbal commands, because you can't control whether or not that other person is going to obey your commands. That's beyond your control. That's up to them. But the other reason you give verbal commands is to compel that person to either obey those commands and act consistent with someone who's no longer an apparent threat, or to not obey those commands and act consistent with someone who is an imminent threat, and remove any ambiguity from the situation and provide an evidence-based rationale for your use of defensive force. And again, you can hear the stress in this officer's voice, the breathing, the high rate of breathing. We encounter this all the time when we do our own law self-defense live courses, level 1 live courses, and we run people through a simulator, a self-defense shooting simulator after the fact. Just like this, the videos we show them that they have to respond to with this fake pistol, this infrared pistol, they're only about 30 seconds, 40 seconds long. And of course, everyone knows it's fake. The video is not going to jump out and actually stab you. But when those 30 or 40 or 50 seconds are done and we turn the lights back up and we ask that person to tell us what they saw, what they did, and why they did it, they often can't tell us in any coherent way. Their respiration is obviously up. Their hands are shaking. They can't remember what they did, or if they do, they can't remember the sequence in which they did it. They can't remember what they saw. Or if we suggest things that weren't in the video, they agree that those things were in the video. And we all know they weren't there. So all of this stress plays a real role, folks, in terms of your ability to accurately perceive, to store, to recall information about the event that actually happened. And this does play a role in your ability to articulate what happened after the fact. There's a reason law enforcement is typically given 24, 48, 72 hours after a use of force event, especially a deadly force use of force event, before they're required to give a formal statement. And the reason is to allow all those brain chemicals triggered under that stress to metabolize out of the system so the brain's coherent again and operating in the normal way. Folks, I know a bunch of you are putting comments in the comments, and that's awesome. And if time allows, at the end of the show, before we close out, I will scroll through all of those and answer as many questions as I have. We try to keep the show to an hour. But I'm not going to break the show every couple of minutes to answer those comments because we'd never get through the planned content. But I do encourage you to put the contents in there, and if we have the time to answer them, I'll be happy to do that. All right, so that was the second video I wanted to share with all of you. The third video now is the big one, and that's the one we're going to spend the most time on, do a detailed legal analysis breakdown on, and that is the one of the two men, masked men, armed with pistols, amongst other people present, protesters present, cohorts of theirs present, facing down a blue pickup truck that presumably was just going about its business before it found itself stopped by two masked men bearing pistols. So Before I jump into that, however, I have another message I'd like to share with all of you, and that is, as I said at the start, most of our content is intended for Law of Self-Defense members only. This Thursday show is really the only exception to that. And you might be wondering, well, what's the cost to be a member? The good news is it's dirt cheap, especially the trial membership. So you can become a silver level trial member for just 99 cents for 2 weeks. And if you don't like it in those 2 weeks and you decide it's not for you and you cancel, we'll refund not just 100% of your money, but 200% of your money. Now, granted, that's not much. It's just an extra 99 cents. But let's face it, we didn't ask you for much up front. And this gives you all the access to our content that any other silver level member would have for that 2 week period. Now, after the 2 weeks, it goes to the normal price, which is still dirt cheap, less than $10 a month, only about 33 cents a day. So if you feel that this kind of content is worth 33 cents a day, welcome aboard. We'd love to have you as a member. If you don't, well, that's your call to make. And certainly I wouldn't want you to spend even a penny on something you believed wasn't worth a penny. But for the rest of you, welcome aboard. We're glad to have you. Try us out. Can you afford not to try it out for 99 cents, folks, to get the rest of our weekly content? It's just not that much. So you can learn more about that opportunity for the trial membership for 99 cents. 200% money back guarantee at lawofselfdefense.com/trial. Okay, back to the core content. Let's take a look now at this first video. So what we're going to see here is really a blue pickup truck. It's already kind of stopped by these protesters in the road, two of whom have pistols in their hand. And that's where we're at. Then the pickup truck will back up a little bit, try to drive around them, continue in its intended direction. There'll be the protesters, including the men with the guns, will run back in front of the pickup truck again. And ultimately, the pickup truck will do a J-turn, slow J-turn, and turn and drive away in the other direction. So let's go through the video first, and then we will step through the kind of 5 elements of self-defense law legal analysis, as well as starting with a very powerful, I hope, cautionary note. Here we go. Okay, so as you might have imagined, I got probably a couple of hundred inquiries asking me to comment on this particular event. So I am here to serve. So let's go ahead and jump right into it. But before we jump into kind of the black letter of the law, legal analysis, whether or not the conditions have been met for that pickup truck driver to resort to deadly defensive force under these circumstances, I want to share what really should be perceived as the usual caveat. And that is, you don't want to be getting into fights you don't need to be getting into, folks. If you can, consistent with the safety of innocent persons, yourself and others you have a duty to protect, exit a confrontational situation without having to threaten or use force against another person, guess what, folks? You just won that fight. That's how law-abiding people win fights, by not having to fight, and you've won it at zero cost. Remember, the moment you get engaged in a physical confrontation, you've just incurred 2 risks you were not incurring a moment before: a greater than 0 risk of dying in that fight, and a greater than 0 risk of spending the rest of your life in prison. We can, through training and practice in the physical realm and in the legal realm here at Law of Self-Defense, we can get those risks awfully close to 0, but they're never 0, folks. It may not just be your day. You may just lose that physical fight, no matter how good you are. And you could lose a legal fight, no matter how innocent you are. That's just reality. So don't expose yourself to those risks if you don't have to. if consistent with safety, you can avoid exposing yourself to those risks. And folks, that's particularly true these days. You don't want to be potentially exposing yourself to the politically motivated decision-making of some of these prosecutors we have out there now who are framing the term justice in terms of racial or gender equity rather than in terms of actual legal merit. To these kinds of prosecutors, you're not a human being with your own inherent value, with a wife and kids and a life and a job. You're just a means to their political ends, a pawn to them. And from the perspective of traditional American ideas of due process and individual justice, their politically motivated prosecutorial decision-making is, to my eye, a form of it's legal sociopathy. Do you want to unnecessarily put your life in the hands of a sociopath who doesn't even think you're human? I would hope not. And can we have any reasonable expectation in today's world that we're going to be treated in a similar manner legally by this kind of prosecutor? Or similarly to the people this prosecutor believes are on his team as opposed to your team? I mean, look at the man who's merely filmed the Ahmaud Arbery event in Georgia from his car. He's now charged with felony murder predicated on attempted unlawful imprisonment, a ridiculous charge. Contrast that with the decision of the just elected prosecutor in Portland, Oregon, who's just announced he's not going to press charges against even protesters who launched deadly force attacks on law enforcement. He's not going to charge them. So they face no legal jeopardy at all for their attacks on law enforcement. Is that justice? Well, I guess by some definitions, some people's definitions, it might be justice, but not by any definition you want to subject yourself to, folks. Don't put yourself in that cage. Now, with that caveat out of the way, that said, if the circumstances make avoiding the fight consistent with safety impossible, well, then you need to win the fight. You need to win that physical fight. And you need to do it in such a way that you're well positioned to also win the legal fight, which is what we help all of you with here at Law of Self-Defense, which means, of course, staying within the legal boundaries for a use of force event. And that means staying within the 5 elements of self-defense law. And those elements are, of course, innocence, imminence, proportionality, avoidance, and reasonableness. And folks, if you're not familiar with those 5 elements of self-defense, first of all, shame on you. You should be familiar with them by now. But if you're not, I have good news. We have a totally free infographic you can get from Law of Self-Defense. The 5 elements of self-defense law infographic. It lists the 5 elements. It briefly describes them. Because, folks, if you don't understand these 5 elements, you don't know anything about self-defense law. I don't care where you've been taught. And you don't know, can't know, how use of force law is applied in the real world to real people in any disciplined way. So please, I urge you, it doesn't cost a penny, folks. It's a free downloadable PDF. You can get it at lawofselfdefense.com/elements. If you're perhaps an instructor and you like the infographic enough that you'd like a poster size for your classroom, we have posters available as well. They're not free because we have to print and ship them, but you can find access to those posters at that same link, lawofselfdefense.com/elements. But please don't feel obliged to buy a poster. Just, if nothing else, download the free PDF, lawofselfdefense.com/elements. Please, because otherwise none of this makes any sense. So let's take a look at each of these elements in turn in the context of this pickup truck event. Element of innocence, the first one. This really asks, who is the unlawful initial aggressor in the confrontation? Well, I don't know everything about this case, so I'm assuming the driver of the pickup truck was merely lawfully driving down the road, not seeking a confrontation, just going about his business, exercising his fundamental freedom of travel and liberty of movement. Now, obviously, if that's not the case, if the driver of the pickup truck was some psychopath who decided to start mowing down peaceful protesters with his truck, well, then the driver would be the initial physical aggressor, with the truck being used as a deadly weapon, and a deadly defensive response by the protesters being run over would almost certainly be appropriate. But there is, of course, no evidence that the pickup driver was doing anything unlawful, whatever, when he was confronted by the 2 masked gunmen in the street. And therefore, it's the 2 gunmen who are acting unlawfully and threatening the pickup driver with deadly force. They're not responding, those 2 gunmen are not responding to some unlawful deadly force threat. So the requirements for the element of innocence are checked off favorably for the pickup driver. He's got that required element. What about the second element, imminence? Was the threat facing the pickup driver an imminent threat? In other words, was it a threat immediately about to happen? Now, a great way to evaluate imminence is to apply a framework, a conceptual framework known as the AOJ triad: ability, opportunity, jeopardy. And by the way, folks, if you were taught AOJ or a similar framework as if it were the entirety of self-defense law, you were badly misled. AOJ is a very useful conceptual framework, but it applies to only one of the 5 elements of self-defense, that element of imminence. All the other 4 elements still apply, are still required, unless they are independently waived for some reason. So you can have AOJ and still not have lawful self-defense, folks, if one of the other required elements is missing. Be very careful about that. A lot of instructors teach AOJ as if it were the entirety of self-defense law, and they do that mostly by presuming that the other elements are present. But often they're not, folks, and they're all targets for attack by a prosecutor in going after your claim of self-defense. So you need to be aware of all 5 elements, not just imminence, represented by AOJ. In any case, AOJ stands for ability, opportunity, jeopardy. And when all 3 of these components are present, well, then we have an imminent threat. And then the element of imminence is checked off, and that second step towards meeting the conditions to justify a defensive response has been met. So what do those each stand for? Well, ability has to do with whether or not the aggressor has the ability to cause harm to the defender. Well, we all have some ability to cause harm, right? Of only our fists, our feet. So the real question is not whether there's really an ability to cause harm, but the degree of harm. Do we have an ability to cause only non-deadly harm, or do we have the ability to cause deadly harm? And that distinction between non-deadly and deadly really falls within the scope of proportionality, which is the third element of self-defense, which we'll talk about in a moment. So we'll cover that in detail then. Here we'll just assume ability exists. The next element of AOJ is opportunity. Does the aggressor have the opportunity to immediately bring that ability to bear against an innocent victim, presumably the defender? Now, imagine the 2 men in this instance were not armed with guns, but were armed with knives instead. If they were armed with knives, would they have the immediate opportunity to stab the driver of the truck? Arguably not, right? They'd first have to get within contact distance of the driver, and they'd have to breach the vehicle. That may not take much time, but it's not instant. Of course, if they did breach the vehicle, then they would clearly have opportunity to bring a knife to bear. But of course, in this case, the men are not armed with knives. They're armed with guns, projectile weapons. And if your attacker has a gun and he can see you, it's virtually certain he has the opportunity to bring the ability of that gun to bear against you if he wants to. That's the nature of firearms, throwing hot lead fast at long distances. You can't outrun a bullet. You can't outdrive a bullet. This pickup driver cannot outdrive these 2 men's bullets. So they clearly have the opportunity to use their guns against them. So we can check off the O of AOJ. The J, of course, is jeopardy, because you can have ability and opportunity and not be an imminent threat. There must also be jeopardy, meaning an apparent intent on the part of that aggressor to bring that ability and opportunity to bear against an innocent person. Now, a good example of a situation where you have ability and opportunity but don't have jeopardy might be simply the presence of a uniformed police officer standing nearby. He's got ability, he's got his gun, he's got opportunity, he's only a few feet away, but there's no jeopardy. There's nothing about his conduct from which we can infer an intent to use that ability and opportunity against an innocent person. In this case, do we have jeopardy from those 2 men with the guns? Is there conduct from which we can infer an intent to use unlawful force against an innocent? I'd argue that we do. These are not 2 guys who are open carrying and the guns are in their holster. We can look at the aggressive positioning of them in front of the path of the pickup truck. They're in the road. They're arguably committing an unlawful arrest under this circumstance, an unlawful imprisonment by stopping this pickup driver from lawfully continuing on his journey. Not only that, they have the guns out. The guns are at a ready-to-use position right now. Clearly, the 2 masked armed men are communicating an intent to use unlawful force against the pickup driver, and it would be reasonable for the pickup driver to make that inference from their conduct. particularly since when the pickup driver goes to the other side of the road, the two men with the guns run over to stand in front of his truck again with the gun still at low ready. So that conduct checks off jeopardy. That gives us ability, opportunity, and jeopardy, meaning we have, in fact, an imminent threat. But you may wonder, what about the fact that the two men, well, they're not shooting yet, right? Well, you're not required to wait until the gun-armed aggressors actually start shooting at you. You're privileged to defend against the shooting that's imminent, that's reasonably perceived as being immediately about to occur. Obviously, self-defense wouldn't be very helpful if you had to wait to get shot first. The next element, proportionality, has to do with the degree of force involved in the attack. You can only use deadly defensive force if you're facing a deadly force threat, with some exceptions. Here, of course, the two masked gunmen are threatening the pickup truck driver with guns, which are deadly force as a matter of law. With the pickup truck driver facing a deadly force threat, he's privileged to use deadly defensive force, assuming, of course, the other elements of self-defense are also met. Now, can that deadly defensive force be in the form of his truck, just driving these two gunmen over? Sure. Use of force law doesn't really care about the particular manner of deadly force. It really only cares if deadly force is justified, period. If deadly force is justified, then the form of that deadly force could be a gun or a knife or a piano dropped from a great height or, in this case, a pickup truck. It doesn't really matter. That brings us to the fourth element of self-defense, avoidance. This involves the issue of whether the defender violated some legal duty to retreat. Even if we assume this occurred in a duty to retreat state, and there's only about 14 of those folks out of the 50 states, so it's a small minority of states that impose a generalized legal duty to retreat. But even in those states, retreat's only required if it can be accomplished with complete safety. You're not required to increase your jeopardy in order to attempt to retreat from an unlawful threat of force. At least if you're not the initial aggressor, and we've already presumed that to be the case. When your aggressor is armed with a gun already displayed, is it really possible to retreat without increasing your jeopardy before that imminent threat can be used against you, especially when your ability to retreat is constrained by the many other people on that guy's team who are surrounding your vehicle? Is it possible for you to do that without endangering those other people, backing over them, for example? I'd argue not. And if safe retreat is not possible, then the duty to retreat, even if it would otherwise have existed, is not imposed. So we can check off the element of avoidance for the pickup driver too, and that brings us to the fifth and final element of self-defense, reasonableness. And this asks whether, first, did the defender have a genuine good faith, subjective belief in the need to act in self-defense? And second, was that belief objectively reasonable? In other words, would a theoretical, reasonable, and prudent person in the same position have shared that subjective belief? Now, absent an interview with the truck driver, we'll have to presume that he had a subjective perception of an imminent deadly force threat. Certainly, the reasonableness of such a perception seems well-founded. The driver did not see two men who were actually armed with bananas and mistakenly and unreasonably perceived that the bananas were handguns. He saw two men with apparent handguns threatening him with deadly force. So we can check off the element of reasonableness for the pickup driver as well. So with all five elements checked off for the pickup driver, innocence, imminence, proportionality, avoidance, and reasonableness, have all the legal conditions been met for the driver to use deadly defensive force against these two men? I would suggest the answer to that question is yes. Of course, even with the driver possessing all the legal requirements for the use of deadly defensive force, I want to remind you of my caveat at the beginning, that if you can avoid the confrontation consistent with the safety of innocent persons without having to use or threaten force, that's a huge win. Grab it with both hands. Don't get into fights you don't need to get into. Don't forget about those sociopathic prosecutors. You don't want to be in their grasp if you can safely avoid it. It is wildly better to be safely at home and at work and with your family and going fishing and living life without a threat of massive criminal liability and perhaps a lifetime in jail, in prison, as I presume this pickup driver has because he ended up not running anybody over. It's wildly better to be in that position than to have unnecessarily, not compelled by the mandate of personal safety, to have driven over some jerks standing in the road waving guns around just because, some might argue, they deserve it. The criminal justice system is not about what other people deserve. Okay, folks, before I proceed on to our questions, I do want to mention, if you like this kind of content, boy, do we have a treat for you. A couple of times a year, we host our Law Self-Defense Level 1 class, live online class. We have one, the next one, the last one for this year, coming up Saturday, October 3rd. This is our full day class taught in a webinar format, taught live by me, not a recording, so there's plenty of opportunity for live Q&A, but streamed directly to your computer, your laptop, your tablet, so you don't have to travel anymore, and more important to me, from my perspective, I don't have to travel anywhere. This is the most in-depth education available anywhere on self-defense law, and I include law schools in that, folks. Law schools do not teach this stuff at anywhere like this depth. In my 3 years of law school, I got a few minutes of self-defense law education. That was it. Now, the class is taught in plain English, so you don't need to be worried about it being too technical. The class is perfectly appropriate for everybody. And in the class, we do answer more than 100 very specific self-defense law questions in the course of that day. And I expect most of you don't know the answers, at least you don't know the correct answers to most of those questions. In fact, I expect many of you don't know the questions, and that's a terrible place to be. We have one more of these classes in 2020, Saturday, October 3rd, and after that, it'll be months well into 2021 before there's another opportunity to take the class. In fact, I think we're only doing 2 of these in 2021. So when those seats are gone, folks, that's it. That's the end of the opportunity. So if you're at all interested in getting an expert knowledge of self-defense law in a single day, the equivalent of a semester-long law school course on use of force law in plain English, then I urge you to at least take a look, point your browser to lawofselfdefense.com/liveonline and see if it's a good fit for you. Okay, folks, let's begin to get to the questions now. The first one is going to be kind of quick because I've already answered it elsewhere, so I'm going to point you to where I've answered it. But someone sent in the inquiry, hey, these violent mobs that have been in the Portland city center doing their rioting, looting, and arson are now beginning to expand outside the city center into neighboring communities, residential communities, threatening those communities, threatening to do, well, what they've done inside the city center, rioting, looting, and arson. And what are those homeowners, those residents in those communities supposed to do? Well, the good news, folks, is we've already done an entire course on this subject. It's our course on, believe it or not, entitled Lawful Defense Against Rioters, Looters, and Arsonists. And the good news for all of you listening today is that this week specifically, we're running an unbelievable combination sale on that course, Lawful Defense Against Rioting, Looting, and Arson, in combination with our very popular Defense of Property course, which covers defense of highly defensible property like your home, your business, your occupied vehicle, as well as personal property, as well as pets. Very comprehensive. Has the defense of property law for all 50 states as part of the course. The combination of those is normally $200, $100 for each course. We're making the pair of these available this week only, folks, for less than $50. So 75% off the normal price for the combination. If that's of interest, and I certainly hope it is, given these chaotic times, I urge you to take a look at lawselfdefense.com/rioters. It provides a lot of detail there on both these courses, and we've never had them as inexpensively priced as we do this week. $49.95 for the pair of these $100 each courses. So that's my answer to that question. What can those people do in defense of their home, their castle, lawfully against rioters, looters, and arsonists? How are those 3 categories of people distinct from each other in terms of use of force law? How do we distinguish in terms of what we're allowed to do in defense of ourselves and our family and our home against peaceful protesters, obstructive protesters, violent protesters, rioters, looters, arsonists? These are all different categories, folks, and the rules of engagement are different for each of them. It's all covered in these courses, so I urge you to at least take a look at those. I think you will enjoy them. All right, let me dive now into the other more substantive questions. So we got a question from a Platinum Protection member asking about the use of unusual non-deadly force weapons, things like paintball guns that fire pepper balls, smoke grenades. If you're in your home and you see a mob of protesters coming down the street, maybe they're protesters, maybe they're obstructive protesters. Maybe they're violent protesters. Maybe they're rioters, looters, arsonists. You may not know yet, but you'd like to be able to deter them from occupying your street in front of your home. We've all seen the footage of buildings being set ablaze, cars being set ablaze, even police officers being subject to deadly force attacks. We'll come back to that in a moment. We don't want to be subject to those. We don't want our wives and children to be subject to those. We don't want our homes set on fire. So what can we do in terms of deadly force self-defense? And some of these deadly force means that have reach, like a pepper gun that fires pepper balls, as opposed to a can of Sabre Red that sprays 20 feet, however much it sprays. Ideally, you'd like to be able to stay in the protection of your home and kind of reach out and touch the protesters in a non-deadly force way. Well, the answer is, strictly speaking, the same legal standards apply as always. We have the 5 elements for self-defense as we just stepped through them, except in this case in the non-deadly force context. Now, we do need to be careful in the non-deadly force context to maintain proportionality within that non-deadly force bucket. I mentioned earlier that really all deadly force is equivalent to all deadly force. Once deadly force is authorized, the law doesn't really care what the form of that deadly force takes. That's not true of non-deadly force. There is a continuum of force within the non-deadly force bucket. Someone pressing their finger against your chest, non-deadly force. Technically, a simple battery, unlawful, but it's a lesser degree of force than if they punch you in the face. Most of those, both of those, I should say, may be non-deadly force, but clearly the punch is more force than the finger poke to the chest. Also, when we talk about any kind of unusual weapons, even in the context of non-deadly force weapons, as a general principle, you want to look like as boring a defender as possible. The more unusual or bizarre you look, the more you look like a theatrical opportunity for a prosecutor. And if you think a prosecutor doesn't like the theater of the courtroom, at least a little bit, well, he probably wouldn't be in that job if he didn't like it. So you don't want to be attractive. You want to maintain as low a profile as possible, as boring a presentation as possible. Odd, unusual, bizarre defensive tools. And it could be almost anything that's unusual. For example, if you have a 40 millimeter mortar that punches out non-deadly force smoke grenades, right? Or non-deadly force pepper spray grenades, well, that's going to look pretty unusual and bizarre. And that will definitely attract attention. And you don't want attention. You want not attention. So long as you can, consistent with safety, be boring. And frankly, it's not clear to me what these unusual non-deadly defensive tools get you in terms of actually being able to better protect yourself, your home, your family, from what really matters, which are not the non-deadly force threats, but the deadly force threats. Of course, that's another whole subject that we cover in those combination of courses I just mentioned that are currently on sale for 75% off. Those combination of courses, lawful defense against rioting, looting, and arson, and defense of property, answers all this in much more detail than we can possibly cover in this show. Several hours of content. All right, let me proceed then to the next question sent in from a Platinum Protection member, and that is, what about the use of weapon-mounted lasers as non-deadly defensive weapons? So we've all seen now in the news protesters, rioters, using arguably deadly force lasers capable of causing blindness. Blindness is deadly force, folks. Using lasers in a deadly force manner, as deadly force against law enforcement officers. Now, I get a lot of questions, well, what's the appropriate response to that? Well, if deadly force is being used against you and the other elements of self-defense have been met, deadly defensive force would be appropriate. You're not required to stand there and get blinded by some lunatic with a laser. Now, there are practical complications of that, of course. The effect of a laser, it doesn't leave, other than the eyeball itself, of course. If you're blinded, well, that's evidence you were blinded. But it doesn't, a near miss doesn't scar your skin, for example. It doesn't burn buildings. There's not brass casings all over the floor. So the effects, the evidence of it having been used can be transient. Also, of course, if you're facing a mob, you don't really know who in the mob is shining the laser. If there's lots of people shining lasers, who's shining at you? You can make an argument that they're acting as a mob and therefore collectively responsible. That's not an argument you want to make if you don't have to. I mean, the best advice, again, is as always, don't be there, be someplace else. If you're law enforcement and you have to be there, brother, sister, you got my sympathies. And I hope that they come up with some protective eyewear for you or allow you to respond effectively to neutralize that threat, which very well might require deadly force. Under the black letter of the law, if someone's using a laser to literally blind you or is eminently about to do that, deadly defensive force would be justified. But what about the lasers we might have on our pistols, right? Many of us carry concealed. I carry concealed. I'm not a big fan of lasers, but that's a personal preference. You've got a Surefire laser, some other manufacturer laser on your concealed carry pistol. Can you use that laser as a non-deadly weapon against a prospective aggressor? The answer is, in theory, yes. I mean, even those lasers, and I've seen them, they have labels on them saying, don't shine it in your eyes. So I have to believe even those lasers are capable of causing perhaps permanent eye injury, if not blindness, then permanent deficiency of vision or sustained deficiency of vision or damage to vision, which even if transient, if it's sustained enough, might qualify as serious bodily injury and therefore fall in the deadly force bucket. But another issue you have, of course, is if the laser's mounted coaxial with your muzzle, as is normally the case, well, then you're muzzling the person too. You're threatening them with the muzzle of your gun. Are you threatening them now with deadly force? Does that, independent of the laser, create a deadly defensive force situation in which you have to justify that on the basis of you're facing a deadly force threat? Also, another factor to consider is we all know that lasers are being used in a deadly force way, meaning in a manner readily capable of causing serious bodily injury, blindness to other people, currently mostly law enforcement, but civilians as well, non-law enforcement as well. We've all seen the footage of that also. If you start shining your laser around, how is anybody around you supposed to know that's one of the good lasers and not one of the bad lasers? And if they perceive it as a bad laser and they perceive it as an imminent threat to their own eyesight, a lot of these crowds are a mix of rioters and peaceful protesters. If you are perceived by a peaceful protester as imminently about to blind them with your laser because they don't know it's a quote-unquote harmless laser, does that privilege them to use deadly defensive force against you? Is that the situation you want to be in? Because it's quite possible for two people to be facing each other, each maybe incorrectly perceiving that the other represents an imminent deadly force threat that justifies their use of deadly defensive force, and they can shoot each other. And they can both be wrong, but they can both be reasonable in their perception, and therefore both lawful in shooting each other. This is not uncommon in plainclothes encounters between police officers who are not familiar with each other. It's not uncommon in active shooter events for cops from different departments or agencies to show up and see they're looking for a guy with a gun. They see a guy with a gun in plainclothes and they shoot him. It turns out, well, it was a plainclothes cop. So again, it's these kinds of complications, ambiguities, uncertainties that are just another layer on top of the rationale for simply not being there. Personally, the use of a laser mounted to my personal defensive weapon as a non-deadly tool would not be my first choice. Now, there is an alternative, of course, because in addition to these deadly force blinding lasers and the supposedly non-deadly force, non-blinding lasers, we also have things like flashlights that strobe. Now, I can tell you it's very different to be behind a strobing flashlight and to be the target of a strobing flashlight. Especially at night, these strobing flashlights are very disorienting. And of course, it's impossible for them to cause any kind of damage to anyone's vision. So that would be my choice before I were using something like a laser to attempt to blind somebody. Next question, also from a Platinum Protection Program member, and we're getting to the last few minutes, folks. They say, all right, Andrew, in your courses, I took your course. You spent about an hour talking about how to interact with the police in the aftermath of a use of force event. And folks, by the way, if you haven't taken that course, there's a lot more subtlety to this than most people think. I mean, for example, you're not going to have just one interaction with the police or one type of interaction with the police. You'll have at least 3 distinct types of interaction with police: 911, the responding officers, and the investigative officers. And they're all different in important ways, and they all need to be treated differently by you. Also, many people are not aware that there are circumstances in which your silence to responding officers can be used against you in court. So, folks, if all you know about interacting with the police in the aftermath of a use of force event is that YouTube video with the law professor who just says never talk to the police, period, I mean, that's one way to go. But if that's all you know, you don't have a well-informed understanding of police interaction, period. Now, in terms of what your spouse should do, you've taken the class, you've heard my hour-long lecture on interacting with the police, but your spouse wasn't in the class. So what should you tell them to do? Well, folks, it's really kind of the same. It's the same issues. How do they respond to stress? How do you respond to stress? If you've taken my course, you've taken a professional's approach to understanding how to interact with the police. You're thought it through. You're planning for it as if it's definitely going to happen someday. Is your spouse doing that too? I rather doubt it, or they would have been in the class too. So if they're not doing that, if they perhaps don't respond well under stress, we're talking life-threatening stress. So it's no, I don't mean to be offensive when I say they don't respond well to stress. Most of us won't. I've told you just now in this class how people respond to the stress of just a simulator that we use in our live courses. But if they don't respond well under stress, or they're not willing to invest the effort, the time, the thought to take a professional's approach to interacting with the police, then probably the smartest move is for them to say nothing, to tell the officers that they're going to defer to you to make any statements. They can do that. Now, might the officer be privileged to talk about the fact that that's what your spouse said at the time? Yeah, but I see that as certainly less damaging than if your spouse simply starts to blather to the cops, maybe with imperfect understanding of what actually happened, maybe not having seen everything that you saw. Those statements are certainly going to be admissible against you in court. So either I would urge your spouse to come take a class, attend our live online course on Saturday, October 3rd, think these things through, to take that professional's approach, or if they're not willing to do that, really don't say anything. Just defer to you on what to say. Finally, the last question we have here is, can defense lawyers object to the prosecution's statements during closing arguments? It's kind of a technical nuts and bolts question, but it has some important implications. So the answer is that yes, of course. Your defense attorney can object if they have grounds for objecting to things the prosecutor is saying during their closing arguments, especially, by the way, if the prosecutor is actually misstating the law for the jury, which is not uncommon in use of force cases, self-defense cases. Often the prosecutor doesn't, frankly, really understand use of force law very well. So they may be misstating it not out of malice, but out of ignorance. And you don't want to be sentenced to 20 years because a prosecutor, however well-intentioned, gave the jury bad law. Hopefully your defense lawyer knows the law, so they know enough to object when that happens. But a second reason is, not only do you not want the prosecutor to do that, but if he does it, you want to preserve that issue for appeal. Now, appeal is not where you want to be, folks. Appeal is a very bad place. It's not a redo of the trial. At the trial, you were presumed to be innocent until proven guilty beyond a reasonable doubt. But if you're on appeal, it's because you've been convicted. You were proven guilty beyond a reasonable doubt. Now all the legal presumptions are against you. You've lost that presumption of innocence. So being on appeal is a bad place. But if you have to be there, then you want as solid a foundation for your appeal as possible. And that means making sure your lawyer was smart enough to preserve those issues for appeal at a trial. And typically those issues are preserved by the lawyer saying, I object, and then giving presumably a basis for the objection. Errors that are made at trial, genuine, true errors, mistakes that are made at trial that are not preserved by an appeal, by an objection, are generally not appealable, folks, unless there's something of constitutional magnitude. And even if they are of constitutional magnitude, preserved errors, objected to errors of constitutional magnitude get a much more favorable review than the exact same error that was not preserved by an objection. So make sure you have the highest level of actual, not just apparent or hoped for, but actual legal expertise on your defense team as possible, because things like a failure to object can not only let bad law or bad evidence get in front of the jury when it shouldn't be there, it can also doom any prospect for appealing your conviction after the fact. And speaking of having genuine expertise on your legal team, last thing I'd like to mention before I look at the comments in the comments, and that is the Law Self-Defense Platinum Protection Program. This program is the only way that you can be guaranteed to have me, Attorney Andrew Branca, personally providing legal consultation to your team if you're charged with a use of force event. And most of the time, folks, when cases come to my office, we end up saying no. Generally, I have to say no because I have too many other prior commitments, and I'm not going to drop those prior commitments for a case that just comes in the door unless you're a Platinum Protection Program member, because then you didn't just walk in the door. If you're a Platinum Protection Program member, we drop everything immediately to consult on your case. And that immediately is important, folks, because it makes a big difference whether or not you can raise that legal defense in a compelling way before the prosecution's too invested in taking you to trial. You want to get off that track to trial as quickly as possible. It's much easier early on. Another reason we often have to say no to taking cases is that, frankly, the client doesn't have the money to pay for the legal consultation. My legal consultations cost thousands of dollars, folks. They're not inexpensive, but they're free to you if you're a member of the Platinum Protection Program. You don't have to spend a penny more than you paid to be a member. And frankly, the cost of being a member for a year is less than a single hour of my billable rate, folks. So you know you're getting a great deal. Now, finally, if you happen to already be a Law Self-Defense member, that would be a silver, probably, member, although there have been in the past other levels of membership that are still grandfathered in. Whatever you're paying for that membership is applied to the cost of the Platinum Protection Program. So the Platinum Protection Program's not on top of your existing membership. Your existing membership rolls into the Platinum Protection Program. So you just have to pay the incremental cost difference. If that's of interest, and I hope it is, I encourage you to learn more by pointing your browser to lawofselfdefense.com/platinum. All right, folks, that is the heart of today's show. Let me go through the comments now. As always, we first go through the comments in the Law of Self-Defense members area at our blog. Members come first. Oscar asks if I'll be presenting at TACCON 2020. I don't know, Oscar. It's up to Tom and Lynn. I was invited to speak again at TACCON this last year, but obviously that this year, I guess earlier this year it would have been. That obviously got derailed because of COVID. I'm not sure what the plans are moving forward. I'm not sure if they're planning to do something online or rescheduling the live event, or if I'll be invited to speak at either of those. If you'd like me to speak, you might ask Tom and Lynn if they'd like me to do that. Obviously, we all get along great. But all these events are very complicated to run. So certainly, I wouldn't take it personally if the changing circumstances made it not viable for me to be there. I talk about this stuff every day regardless, folks, so it doesn't really matter to me. But if I could contribute value to TACCON 2021 for next year, certainly I'd be happy to be there for Tom and Lynn. All right, that's really all the questions from the members. So that was brief. Let me scroll through the comments now and questions from Facebook. Lots of people here. Yes, Shauna, the gentleman who pointed the shotgun at the officers, I believe that was in Roxborough, North Carolina. Let's see. Okay, I should have some little game show music playing in the background, right, as I'm scrolling through these, so you guys don't have to listen to pure silence. Anthony asks, so in these riot situations, where are the police protecting the citizens from rioters brandishing their weapons in a threatening manner? This would be the two men with the guns in front of the pickup truck. Folks, there is nobody. There's nobody. There's really nobody ever. You're not going to be attacked when there's a cop standing next to you. The cops show up after the fact. That's not a knock on them. They're only human. That's all they can do. And particularly in these kind of rioting situations, one, often they're overtaxed. They don't have the resources to send. And if you call them, they'll tell you, nobody's coming. We don't have the resources. Or, especially in these urban centers with these sociopathic prosecutors and government, they're literally told they're prohibited from responding. So they're not coming, folks. They're not coming anytime soon, if they're coming at all. So don't expect that. As always, you are your first responder, and that's even more the case in these rioting situations. Guy asks if we still sell our quarterlies. So for several years, we would take all our content, our videos and podcasts, burn them onto DVDs and CDs every quarter, every 3 months, and make those available as a separate product. We've stopped doing that, Guy. So the content is still available, but it's available in its normal digital form on our website, but only for members, Law of Self-Defense members. And frankly, for the cost that people were paying for the quarterlies, they may as well be a member for $10 a month, and they get all that same content. So there really was no reason anymore to offer it separately. And frankly, burning DVDs and shipping things and packaging things, it just gets too costly and inefficient. Ray asks, what do I get as a member? Ray, I would point you to lawofselfdefense.com/trial. Sign up for the trial, 99 cents. Check it out. See if you like it. The experience is the best way to understand what you're going to get rather than me spending a lot of time talking about it. Ray asks, do I get all your content as a member? The answer would be no. You get our ongoing stream of video blogs, podcasts, and blog posts, and then occasional bonus content as well. So, for example, our members got our newest course, Unlawful Defense Against Rioting, Looting, and Arson, for free. It's just in their member area. So they didn't have to pay anything for that $100 course. But we don't do that for every course, so I don't want to give that expectation. Let's see. How long is the sale on the class? Well, if you mean the combo, 75% off on the Lawful Defense Against Rioters, Looters, and Arsonists class, and the Defense of Property class, we're running our sale this week. So if you're interested in taking advantage of that, this would be the week to do it. Our expectation, our schedule for marketing is next week. Those are back up to their normal price of $100 a piece. So if you'd rather pay $49.95 rather than $199.90, this week would be the week to get those two courses. Henry says he took the in-person course a couple years ago, said he liked it. Thank you very much, Henry. I appreciate that. We used to do 40 to 45 live courses, in-person courses every year, folks. I was traveling that much. We don't do that anymore for obvious reasons. We had stopped even before COVID. If you want a live class taught now, it'll be this live online format that we do a couple times a year. Okay. Let's see. Forrest asks if the 75% off courses are DVD or streaming. They're streaming, Forrest. Okay, folks, I think that is all I have for all of you. Let me see. I got a couple questions from... one question on the YouTube. So it looks like the YouTube streamed properly this time. First time ever. Great. So Floyd asks, how can an elderly person, on the issue of having to retreat from a confrontation, how can an elderly person, particularly with a clear disability, be required to retreat? Well, the law takes that into account. So whether or not it would be reasonable for you to retreat is a function of the totality of the circumstances, what the terrain is like, is there a safe avenue of retreat, but also takes into consideration in terms of the reasonableness of the path of retreat, your particular abilities or disabilities. If you're older, you're going to be less quick, as I'm learning every year, less quick than you were when you were younger. So what might be a safe avenue of retreat for a young, healthy, fit person very well may not be a safe avenue of retreat for an older person. And by the way, this can apply by extension to defense of other situations. So you might be young and fit and healthy and able to flee at speed on foot, but maybe you're with a small child, or maybe you're with an elderly parent. You're not required to leave them behind. So your rate of retreat is now limited to whatever their rate of retreat is. And that would be taken into consideration as well. All right, folks, I think I've answered all the questions. So a bit over an hour now, which I try to avoid. But thank you very much for joining us. Again, I appreciate it all. If you'd like to send in a question for our consideration for the next News and Q&A show next week, that would be, I suppose, August 20th, Thursday, 4 p.m. Eastern Time live. Then I would encourage you to email that to us at show@lawofselfdefense.com. If you are a platinum level member of Law of Self-Defense, at your membership page, you'll find a premier Q&A form where you can submit your questions. They get priority. And if you ask for a private response, I'll provide a response to you privately as well through that form. But if you are a platinum member, take advantage of that form because your questions get answered first. Okay, folks, that's all I have for you today. Until we meet again, just remember, if you carry a gun so that you're hard to kill, and that is why I carry a gun, I have my entire adult life, so that I'm hard to kill, so that my family is hard to kill. If you carry that gun so you're hard to kill, you also owe it to yourself and your family to make sure you know the law so that you are hard to convict. All right, folks, until next time, I am attorney Andrew Branker for Law of Self-Defense.